Good afternoon, ladies and gentlemen. My name is Lucas Kello. I'm an associate professor of international relations at Oxford University, where I also serve as a co-director of the university's Center for Doctoral Training in Cybersecurity. In this panel, we will discuss the mobilization of the legal system to counter nation-state cyber threats. This is an enduring and, in some regards, I think, intractable challenge owing to major obstacles in the legal system. One concerns international law. Nations disagree sometimes fundamentally about how laws and norms of restraint apply in this domain, which has produced a situation wherein Western governments and democratic governments, broadly speaking, restrain their offensive activities far more than autocratic regimes and their proxies do. Another major challenge involves jurisdictional fragmentation. Nations that seek to apply their domestic penal codes to punish perpetrators routinely struggle to do so because they reside within foreign soil and often have an association with their parent government or enjoy its protection. And this is certainly true, of course, of foreign state actors. So this afternoon we have assembled a fantastic group of speakers representing three distinct perspectives on and efforts to address these obstacles. And the purpose of the discussion is not merely to identify limitations in the existing legal system, but also to showcase innovative efforts to overcome them. So we have with us on your far left, Matthew Olsen, who serves as the Assistant Attorney General for National Security in the US Department of Justice, where he leads the mission to combat terrorism, espionage, cybercrime, and other threats to national security. He brings 18 years of experience working at the DOJ as a career attorney and in a number of leadership positions. We also have next to him Major Andrea Ammendola, who brings to us almost 2 decades of experience working with the Special Operational Group of the Italian Carabinieri. His work has included, as we will learn, the development of strategies to counter online activity by Al-Qaeda and the Islamic State. And we are also honored to have with us Helen Rohtla, who leads the Information Society Division at Estonia's Consumer Protection and Technical Regulatory Authority. Her division is responsible for maintaining public order on the internet and in media services, vital responsibilities under the current conditions of intense war propaganda and online hate speech. Now, if I were a cyber criminal, even one tied to a nation state, and I'm not, I would not want to confront any of these individuals and their institutions. It's a pleasure to have you with us today. So first, I turn to Matt, who will discuss the Department of Justice's work within the US legal system to thwart foreign cyber threats.
All right, well, thank you very much. I really appreciate the opportunity to be here. Thank you, Lucas. Thank you to my esteemed fellow colleagues. It's just it's a real privilege to be here in Estonia and to be part of this extraordinary conference. And hats off to the folks who put this together. This is a crucially important time for us to gather as NATO allies and other partners. I know that the crisis in Ukraine is front of mind for all of us, in particular the inspiring bravery and the resilience of the Ukrainian people who are fighting to defend their families and their homes and their democracy. I know that's something that we're all thinking about. And it's also a profound reminder of the values that we all share in this room and our commitments and our shared responsibility as we discuss the important policy and legal topics that have been front and center during this conference. So let me begin by talking just a little bit about what I do at the Department of Justice. I'll talk briefly about that. Then I'll turn to touch on the nature of the cyber threat landscape as we see it in the United States. And then I'll talk briefly about some of the things that we're doing within the federal government, within the United States, to address the cyber threats that we're facing. So, as many of you know, the Department of Justice, where I work, is the lead federal agency for enforcing the laws of the United States. There are different parts to the Department of Justice. There's main justice, and then there's a number of field offices or U.S. attorneys' offices. I lead a division of the Department of Justice, the National Security Division, As you said, Lucas, we focus on counterterrorism, counterespionage, cyber threats from nation states and other threats to our national security. We also play a key role in bridging the law enforcement agencies within the United States and the intelligence community. So that's, we often work with classified information. We figure out how we can use classified information, for example, in criminal prosecutions. And as many of you know, as all of you know actually, what we are seeing in terms of cyber threats are now among our greatest national security threats. And our job in the National Security Division is to go after nation-state actors who carry out malicious cyber activity inside the United States. And this is an area of increasing complexity. Let me talk just a little bit about the nature of the cyber threat landscape that we see. There's just a number of ways in which nation states in particular, and when we talk about our adversaries, we really are talking about 4 significant adversaries: Russia, China, North Korea, and Iran. And in various ways, these nation states act to steal our technology. They carry out economic espionage to steal trade secrets from technology companies, for example. They amass personal information about U.S. citizens to build databases about our citizens. They seek to influence, either covertly or even overtly in a malign way, our democratic processes. And then through various cyber means, they seek to hold our critical infrastructure at risk to either disruptive or even destructive attacks. Let me just give you a few examples of what I'm talking about. And again, these are going to be examples that are going to be quite familiar to folks in this room. For one, last year we had the government of China engaging in a malicious cyber campaign that exploited vulnerabilities in the Microsoft Exchange servers in order to compromise victims. It was a massive operation. It resulted in significant costs for primarily private sector victims. Iranian government actors have interfered with critical infrastructure systems in a broad range of victims within the United States. And then North Korean government actors have robbed cryptocurrency exchanges and central banks, stealing hundreds of millions of dollars that are used in some ways to evade sanctions and to support their weapons programs. So look, at DOJ, like across the federal government and across with our allies as well, we are particularly focused on Russia for very good reason. You take, for example, the recent cyber attack that Russia carried out in Europe against satellite internet infrastructure, the Viasat attack. As Russian troops were preparing to move into Ukraine in the early morning hours of February 24th, satellite internet connections were suddenly disrupted in Ukraine. This attack by Russia against the satellite ground systems, the infrastructure, plunged tens of thousands of people in Europe, across Europe, into internet darkness. It hit part of the Ukrainian defenses. A month later, into March, thousands of people in Europe were still reportedly offline, and that included 2,000 wind turbines in Germany. So this is just one of the latest examples of how Russia has used its cyber capabilities to support its invasion of Ukraine. Russia's SolarWinds attack last year, carried out by their intelligence service, by the SVR, attacked and compromised tens of thousands of networks globally, including in the United States. We're very concerned about the attack and the effect on US government systems, part of a massive spying campaign. So then you go back to the most costly cyber attack in history, the 2017 NotPetya attack, carried out by the Russian military intelligence, the GRU. That, in fact, was a destructive attack. So this is a pattern by the Russian government, and we are bracing in the United States for more attacks. The White House recently reiterated the warning that there could be potentially Russian actors who would carry out malicious cyber activity, including as a response to the unprecedented economic costs we've imposed on Russia alongside our allies and partners. So, what are we doing about this? What are we doing about this cyber threat landscape, and particularly when it comes to Russia? And I think, our general strategy is to use all of the legal tools in our arsenal. One of our core authorities, of course, is the enforcement of our criminal laws through investigation and prosecution. We believe it's essential that we hold criminal actors accountable, and it's also one way that we can publicly inform private companies and the general public about the nature of the threats we face. So this past March, the Department of Justice and my division announced charges that we had returned against 4 Russian nationals associated with the Russian government for their involvement in 2 campaigns that targeted critical infrastructure, not just in the United States, but globally, in the energy sector between 2012 and 2018. One of those cases charged a Russian national who was a member of a Russian military research institute with a multi-year effort to hack into industrial control systems, companies overseas and in the United States. And the goal was to physically damage the safety functions of these systems. In another case, we charged 3 Russian intelligence officers with targeting software and hardware control systems of companies in the energy sector to gain surreptitious and persistent access to those systems. So this is the kind of activity that really vividly demonstrates both the capability and the intent of Russian government actors. They have global reach and ambition. And that's one benefit of these indictments, these public charges. But it's not the only one, because in these cases we haven't arrested anyone to date, but that doesn't mean we won't. We have long memories, and we are patient. And that includes not just the Department of Justice, but our primary investigative agency, the FBI. So beyond what we do when it comes to criminal charges, we also are looking to be proactive. We know that prosecutions are not the only thing that we can do at the Department of Justice, and in fact, we are looking for ways to actually prevent these attacks before they occur. And so even when an arrest may be unlikely, we prioritize the disruption of criminal cyber activity. So recently, we have taken a more proactive approach. And let me give you a couple examples. This goes back some time to the Microsoft Exchange server attack of last year, where, as I mentioned, we had 0-day vulnerabilities by a Chinese government hacking group that was sponsored by the Ministry of State Security. And through these vulnerabilities, the group, the Hafnium actors, were able to place web shells on mail servers, allowed for access to the content of email, as well as the ability to place additional malicious files, effectively giving Chinese intelligence the ability to spy on a wide range of victims: universities, law firms, think tanks, non-government organizations. So private sector mitigation had some benefit, but nearly a month after these vulnerabilities were discovered, there were still hundreds of these web shells still on US servers. So running this software. So with court approval in April of 2021 of last year, we were able to conduct an operation that actually removed the remaining Hafnium's web shells. These could have been used to maintain access, and this was, again, an authorized court order that gave us the ability to do this. A similar activity that we undertook just a few weeks ago involved malware known as Cyclops Blink. And this is something that an attack that the Russian military intelligence service, the GRU, had carried out. We had identified this malware that was connected to the GRU, and it had established a series of botnets, and we were able to, again, use our court-authorized search and seizure authority to remove the ability of the command and control layer to manage this botnet. Again, it's sort of a traditional search and seizure authority that you can use in a regular criminal case, and we were able to use it as an authority to remove the instrumentalities of that crime, that is the malicious code. So that eliminated the ability of this command and control layer to control the botnet. It's just a good example of how we're looking to leverage the legal tools that we have in new ways. So these are traditional legal tools that we are leveraging in new ways in this cyber context to have real impact in an operational way. So we have additional tools that we also can rely on in this all tools approach. We look to forfeiture. We also, through the FBI, work with our partners to provide targeted intelligence to the private sector to give them the information they need. Sometimes we declassify classified information. And we recognize that this is not the only set of tools that we have, that law enforcement is a part of a broader government-wide effort. So we look to see us as a force multiplier to use our unique authorities along with Treasury Department and State Department and Defense Department, all of our partners in the federal government who have their own authorities that we can use. So look, I think that's probably enough for now in terms of the way in which the Department of Justice is providing support and coordination with our partners in the federal government, as well as with our partners in other countries and our allies. This really kind of just scratches the surface, and I know we'll have some questions to respond to. So again, thank you very much for the opportunity to participate in this hearing, and I look forward to hearing to our other panelists. So thank you.
So thank you, Matt, for those very informative comments. So now, to me, some of what you said reflects a recognition of the limitations in the existing legal system, at least as it's been applied before, right? Because you said, there's been a lot of movements, and we've seen this, I think especially after the DNC hacking in 2016, to indict and attempt to prosecute individuals involved in these kinds of activities residing abroad. But you also began to outline for us a more proactive approach, right? And that, to me, again, seems to suggest that there's a recognition of limitations with indictments. And what's interesting, something that you said that really caught my eye, is this notion that you're interested in preventing offense activity. So that to me is really interesting because in my research, for example, I'm interested in how legal doctrine interacts with strategic doctrine. And by speaking of prevention, you're starting to invoke questions about deterrence and conflict prevention and so forth. So I was wondering if you could say a little bit about how in your office you have tried to align the work that you do in terms of indictments and prosecutions and proactive activity, aligning that with diplomatic efforts with the Department of State, for example.
Yeah, thank you for that question. And it is the case that and I think that we are one part of a broader ecosystem, and there are limitations to what we can do based on our ability to investigate and prosecute individuals who break the law, violate our criminal laws. And so we are always looking for ways, obviously, just like we've learned from the counterterrorism fight, the goal really is to prevent these acts from taking place to begin with, right? Not just to investigate and prosecute them when they occur. So we work very closely with the State Department, to your question, Lucas. So, and I'll give you, and as well as with the Defense Department and their capabilities and the Treasury Department, which I also mentioned, I'll give you an example from last year. I mentioned the SolarWinds attack that was carried out by Russian intelligence. In April of last year, the president announced a series of actions to sanction Russian actors in connection with that. Sanctions meaning that that U.S. companies cannot do business or cannot interact with those sanctioned entities. And it included 6 technology companies in Russia that supported the work of the intelligence services. In addition to announcing those sanctions, and I should say, what we do in the Justice Department is that we enforce those sanctions. So Treasury and State have the authority to impose the sanctions, to name the sanctioned entities. The Justice Department then can prosecute any entity, any individual or company that violates those sanctions by doing business with those sanctioned companies. Obviously, this is something that we're doing right now with respect to Russian oligarchs. In addition, at the same time, the FBI and the Department of Homeland Security named this as a Russian attack and gave warnings and advice to the private sector on how to remediate. So I think the SolarWinds attack and the way we responded to it sort of starts to give a picture of a series of actions that different legal authorities allow different departments to take that start to build knowledge, resilience, and prevention and deterrence into a broader strategy.
Yeah, it really is important, I think, also to emphasize the more proactive approach that you've taken, because let's be honest about it. If I were a Russian state or private criminal based inside Russia, and I were indicted by your office, I very well might print that out and hang it on my wall as a mark of distinction, right? But now with the more proactive approach, and also with the closer coordination with the Department of State and pursuing other diplomatic avenues, well, then the world starts to close in on me a bit more.
Correct.
Right. Okay, so thank you for that.
Thank you.
Next, we will turn to Andrea, who will discuss the Italian police force's efforts to combat extremist exploitation of the internet.
Okay, thank you very much. It's an honor to be here. I have to say that it would be easier for me to face a group of terrorists than this audience. So it's not, it's not something I'm used to. I'll try to do my best. I'll deal with non-state violent actors, exploitation leaders, terrorist organizations, terrorists in general, because this has been my work for the last 20 years, as Lucas mentioned. And essentially, the internet was a game changer for terrorism because it allowed terrorist organizations to control channels of distribution of propaganda, of ideology. And this was something that they couldn't do before because they had to rely on traditional media that they couldn't control. So I'll try to provide you with an overview of how terrorists has managed to find new opportunities and how the legal tools that are available to governments and states were developed in association with iterations of innovations by terrorist organizations and counter-innovations by governments and security agencies. So let's start from the beginning, the first iteration of this innovation, counter-innovation, that is the centralized control. So at the beginning, the terrorist organizations managed to exploit the internet as a new channel for radicalization using a forum, terrorist forum. This was done by Al-Qaeda in Iraq in 2003, more or less, when they established forum that they directly controlled. These forums were important not only because they were used to to publish propaganda, so to spread their radical and extremist ideologies, but also because they allowed terrorist organizations to move communities from the physical world to the virtual world. So before obviously there are two pillars in radicalization. One is ideology, the other are networks. So it's important face-to-face relations. Now it became increasingly more difficult for Al-Qaeda to have this face-to-face interaction in the physical world after 2001. So they managed to move these interactions with their supporters from the physical to the virtual world. So in these forums, they were important for radicalizations, and after radicalization, they also provide services like terrorist training and terrorist recruiting. So they were essentially in this, they were like conveyor belt in which supporters entered as just like a supported and produced terrorists. Now, what was the legal response to this challenge? So the new challenge, because before 2001, essentially radicalization occurred in the physical world. Was the application of the traditional criminal law to this new reality. Obviously, this criminal law had to be adapted to this new challenge. For example, training was before the internet was conducted essentially face-to-face. While in the internet, for example, the trainer can just upload terrorist manual and videos, and then the trainees can download them and train on their own. So the legislation had to be adapted to a different kind of criminal conduct. Here you can see an operation we conducted in Rome. My team conducted in Rome against two people that run and managed a jihadi website that was used also to recruit people in 2012, 2013, and through the forum they managed to put in contact volunteers for Syria with Jabhat al-Nusra, that was essentially an offshoot of Al-Qaeda in Iraq at that time. So the second iteration of this cycle of innovation, counter-innovation, was the decentralization, because it was increasingly difficult for terrorist organizations to manage directly forums. So they essentially, this was ISIS in 2014, more or less, they asked their supporters to establish networks exploiting the rising use of social media. And they use these networks to spread propaganda and for radicalization. So with this new threat, the traditional response was useless because it was impossible to investigate all these people. We are talking about around 50,000 Al-Qaeda supporters, ISIS supporters. Each one were actively involved in this operation of using the internet for terrorist purposes. So what was the response let's say, started in 2015, 2016? The response was to involve internet companies. So internet companies that managed this platform that was abused by terrorists. In this case, essentially they used social media and I mean, the EU, I'm talking also about Europol, that had a leading role in this, in countering this phenomenon. They asked these companies to take responsibilities for what was published in their platforms. So initially they don't want to do that because for them the responsibility was not theirs, but where the users were responsible for the content published. But especially when ISIS started publishing videos of beheading, if you remember, of American and British citizens, then they decided to cooperate with security agencies. So essentially the system worked like that. The states, including Italy, established internal referral units that essentially tried to identify material and accounts that were used to spread terrorist propaganda. This IRU, they referred this content to the platform that removed them. Now, this was a voluntary cooperation by internet companies, but in 2021, the EU issued a regulation in which this cooperation is now mandatory. So internet companies are required to remove terrorist content, to close accounts used by terrorists in 1 hour after being reported. So it's very short time. So at the beginning it was voluntary, now it was... so in this case, you see that the response to this kind of use of the internet was shifted from essentially investigating, arresting, and prosecuting people to preventing people from preventing terrorists from exploiting the internet. In the third phase, that it's the new one, let's say so, and it's the emerging threat, is the exploitation of this free speech. So beforehand, I mentioned the fact that terrorists use the forum or social media to spread and publish terrorist propaganda that was clearly terrorist. I mean, it was videos of beheading, videos of terrorist attacks, videos of inciting people to commit terrorist attacks in Western countries. So it was clearly terrorist material and illegal material. But anyway, in the same years, some people started to exploit freedom of speech in our society to spread extremist ideologies without inciting clearly to terrorists. So in this case, they wanted to avoid being labeled as terrorists, at least legally, but they obtained the same results. So they used these platforms to radicalize people. And for example, in Italy, we arrested an important Islamist preacher that had established in 2015, more or less, a website which had, on surface, was not illegal, but was used then at a deeper level to recruit people for the jihad in Syria and Iraq. Now, the problem with the exploitation of the free speech for extremism, to spread extremism, is that the traditional legal tool, criminal legal tool, cannot be used because it's difficult to criminalize extremism, because it's difficult to define, to give a definition of extremism, and obviously there is the danger of harming one of the fundamental rights in our societies, so the freedom of speech. However, these extremist networks represent a serious threat, because from these networks periodically emerge threats, terrorists. So it's not like before, in which terrorists produced extremism, in there was the aim of Al-Qaeda and Islamic State. Now terrorism is produced by extremism. So beforehand we had a top-down approach in which radicalization was top-down. Now radicalization is bottom-up. So terrorism emerges from. So for example, we had in Italy we had one of these people that shot at immigrants. It was after reading material in the internet and social media that consider immigrants as a threat for Italy, as a threat, and then tried to kill them in 2018. And this person, that was Luca Traini, was a role model for example, the Christchurch shooter in New Zealand, but also for the recent responsible of shooting in Texas. So, and also these networks produce also different kind of security threats, for example, related to the recruiting of mercenaries for the Donbass. So in 2018, we conducted an investigation in which at the end of this investigation, we arrested 6 people for being mercenaries and for fighting with Russians in Donbass. And apart from this was a non-terrorist threat, but obviously it can produce, and there is a raising consciousness that these people, when returning to Italy, may represent also a security threat. And these people also use the internet to spread the Russian narrative on the conflict. Now, what is the response to this kind of presence of virtual community? The response was to use the internet companies' terms of services against these networks. We cannot have a legal, a criminalization of extremism because of the danger of censorship. And so we used the terms of services I mentioned. I copied one in the slide that forbids the use of the platforms to spread hatred towards other groups in order to cooperate with the internet companies and close accounts and delete content that are not illegal but extremist anyway. So you can see there an operation conducted by Europol and other countries in which they used the term of services. They reported legal but extremist accounts to the internet companies, the police, this internet referral unit, and this content and these accounts were closed and removed. So just to sum up, I try to provide you with an overview of how the legislation, the legal tool developed in cycles of innovations and counter-innovation. And as I mentioned, it all started with the application of criminal law, then it shifted to a more preventative regulation, and then to the use of the term of services, which is not a public law, strictly speaking, against extremism. There are probably, just to conclude my presentation, 3 trends that can be identified in these cycles. That is the shift from national legislation to international legislation, the shift from prosecution to prevention, and the shift from an institutional response based on security agencies to the involvement of private companies and also, I would mention, the civil society. Thank you very much for your attention.
Thank you very much, Andrea, for those comments. Now, I want to take the opportunity of having someone with your extraordinary experience and understanding of institutions to ask you a question about organizational reform. Because much of what you said reminded me of a common distinction within the academic literature on governmental reform between the effectiveness of an institution, which denotes its ability to achieve its stated objectives, and the institution's robustness, which is about evolving, changing the institution so that it can address new objectives that it was not originally designed to achieve. And in this regard, I think it's notable that you said that innovation often happens from the bottom up. This is certainly true, as you pointed out in the presentation, in the second phase, right, on the criminal side of the divide with the decentralization that happens. So I'm interested in knowing more about how your own organization in the police force, which is traditionally hierarchical, right, a top-down organization, and others like it, were able to innovate, right, without necessarily inverting the hierarchy.
Yeah. Well, it's an interesting response. It was very interesting to understand the innovator. I mentioned another aspect. I'm interested in intelligence because I just... The problem is that obviously, in general, talking about management, organizational management, decentralized organizations are more able to innovate than centralized and hierarchical organizations. So it's not easy for the police as an institution, and especially, I think, a military institution, to innovate, because we more tend to be on the traditional side. I mean, we more rely on tradition. We are, especially institutions, public institutions, are fears of losing the appeal they have on public opinion if they innovate, if they change. So this is an aspect. I think that terrorist organizations were incredibly good at innovating because of this, the bottom-up, innovation. So that it wasn't them, it wasn't a terrorist organization that decided to use social media platform. Their supporters started to use them. And then this organization accepted and exploited this innovation that was introduced by supporters. So how can we counter this ability to innovate? I think that we have been very good at innovating, but a little bit slow. So I think that in general it's important to anticipate these terrorist innovations. They anticipate opportunities. For example, a few days ago I was in The Hague and talked about at a checked web meeting, the meeting of Europol, and we must start thinking about how terrorists could exploit the metaverse, how could exploit blockchain technology, how could exploit, for example, decentralized platforms before they really start using them. Because, for example, social media it took 4 years in order to respond in an effective way. So analysis and forecast is very important. And the other factor that is important for public institution, is the private, we mentioned that, public-private cooperation, and also the cooperation with the academic world that must be developed. So it's difficult, institution must develop within the organization process of innovation, but they also can import them from the outside.
So that's an interesting idea. If you can't necessarily invert the hierarchy in order to spur innovation, you can at least branch out horizontally rather than vertically.
Yeah,
so.
I mean, this is in general in the business world is one dogma, that is decentralized organizations are more able to innovate than hierarchical ones.
So I think the challenge implied in my question applies to the organizations of our other two speakers. It may be a question that we will return to later. But next, I want to turn to Helen, who will discuss measures to combat war propaganda and hate speech in Estonia, emanating largely from across the border to the east, I imagine.
Hi, thank you for inviting me. We are definitely not experienced as my co-panelists, but I will try to give you a short overview of what we have done regarding the Russian war propaganda and hate speech online. But firstly, I would like to share with you how propaganda works. Propaganda is aimed to cause confusion, panic, and fear, and shape people's opinion about the enemy. This may be done by simple name-calling. The most well-known Russian narratives in Ukraine have been that Ukrainians are Russophobes, fascists, and Nazis. Russians have been scared with the thought that Ukraine, but go even further, the whole Western world is planning to attack Russia. NATO's continued presence in Eastern Europe is a clear evidence of this, that is in the opinion of Russia, of course. And Russia must stand for its geopolitical interest in the region. Russia needs to protect ethnic Russians from discrimination in foreign countries, like in Ukraine, but the same narrative has been used in regard to Baltic states. And tons of fake news have been produced to illustrate this narrative. Therefore, to protect Russia's interests and fellow Russians living in Ukraine, it is important to demilitarize and denazify Ukraine. Now, here's a great example how symbols are used in propaganda. This poster was published in Crimea prior to Crimean status referendum in March 2014. It carries an easy and understandable message. Either you see your bright future with Russia, or you support the Nazis, that being Ukrainian government. Propaganda messages need to be kept simple. They are to attract masses. To many of you, this poster might not affect your decision-making, but I think we need to understand that something like this is never the first propaganda message. Before that, it's necessary to prepare our audience, that is to spread disinformation on alleged discrimination of ethnic Russians, but also undermine the local government. In case of Ukraine and also many other former Soviet republics, slow but increasingly more aggressive information operations have taken place since the collapse of Soviet Union. Kremlin emphasizes on a crucial role of information and psychological operations in spread of confusion in regard preparation and conduct of military actions. The Gerasimov doctrine is named after the Chief of General Staff of Russian Armed Forces, Valery Gerasimov, and became widely known in 2013 when he published his article in which he emphasizes the importance of non-military components of modern warfare, estimating the ratio of non-military measures against the military to be 4-to-1. Even the chief editor of Russia Today, Margarita Simonyan, has publicly recognized state-owned or controlled media being part of Russia's weapon arsenal. So the question rises, should such media outlets freedom of expression be unconditionally respected, and should freedom to receive information from these sources be guaranteed? Of course, freedom of expression still needs to be respected, but it's important to remember that with every freedom comes responsibility. Freedom of expression must be exercised responsibly, respecting the rights of others. It is important to understand that at the moment, the same values we so highly cherish, democracy and freedom of speech, are actually used as weapons against us. We need to preserve and protect democracy against Russia's destructive policy. Freedom of expression should not be unconditionally respected in case national security, public safety, and rights of others are at risk. And of course, it is important to understand that every restriction still needs to be lawful, necessary, and proportionate. But spreading war propaganda is clearly prohibited by International Convention of Civil and Political Rights adopted by the UN. European Union Council framework decision on combating certain forms of expression on racism and xenophobia by means of criminal law clearly states that member states need to criminalize public inciting to violence and hatred directed against group of person or a person defined by reference to race, color, religion, descent, or nation or ethnic origin. In Estonia, both spreading war propaganda and incitement to hatred are criminalized, but until February this year, we were extremely liberal. We never before restricted access based on the content of media service. We believed in people's media literacy skills even in the worst of times. Now, speaking of the worst of times, here you can see events from 2007 that took place in Tallinn. We called it Bronze Nights or April Unrest. Estonian government has decided to relocate Soviet World War II memorial from the city center to the Defense Forces Cemetery in Tallinn. The decision was also widely broadcasted in Russian media, often in a hostile manner, accusing Estonians of being Russophobic and discriminating ethnic Russians community in Estonia. We did not restrict any access to any websites or media or web or TV channels before, during, or after these events. Although it was clear that Russian media channels by no means eased the tensions. On the contrary, according to Estonian International Security Services, Russian media helped escalating the events. This experience from 2007 made us more cautious this time around. Knowing how large Russian-speaking minority in Estonia is and how many of them consume Kremlin propaganda on a daily basis, we realized that the events of 2007 might repeat themselves. So what did we actually do to target Russian propaganda? We temporarily restricted access to 7 TV channels. This was done by issuing precept to electronic communication undertakings, retransmitting those TV channels. You may ask why for 12 months? Our reasoning behind that was that it can be assumed that the acute period of Russia's attack against Ukraine and the active cognitive war that might follow might take at least 12 months, but this might be prolonged. Now about the legal grounds. Legal grounds for our decision came from the Audiovisual Media Services Directive. The directive states as a principle that the reception and retransmission of media services shall not be restricted. However, member states may provisionally derogate from this principle in case a media service presents a serious or grave risk to public security, including the safeguarding of national security and defense. Taking into account the significant Russian-speaking minority in Estonia and the increasing aggressive propaganda spread by channels in question, we found that these channels present a serious and grave risk to public security. But besides TV channels available through television, there were many websites which made it possible to watch TV broadcasting and already restricted under the audiovisual media services. And there also were some news portals inciting hatred and spreading war propaganda. Therefore, we needed to restrict access to websites. This was done by issuing precept to internet service providers to block respective domain names in domain servers. Again, the websites had not been blocked permanently, but the restrictions are set for 12 months. Legal grounds for these decisions came from domestic law. As I previously mentioned, both spreading pro-propaganda and incitement of hatred are criminalized in Estonia. In addition, supporting and justifying international crime with symbols such as Z or V letters or the St. George's ribbon, for example, are criminalized in Estonia. Those amendments, the last months, entered into force in April of this year. And as we are responsible for the public order in internet, it was our duty to make sure that those websites are blocked in Estonia. Now, about the impact of our decisions. It is still early days to talk about long-term impact of our decisions, but at least we can see some positive outcomes. We can see that credibility of Russian media has fallen, and daily share of our Russian language public broadcasting channel has increased significantly. Of course, it will be naive from me to say that this is solely the result of our decisions. The beginning of war and the shameless disinformation published in Russian channels has helped to open the eyes of some keen followers. As a national regulatory authority of audiovisual media services, we can also say that there is a noticeable increase among our media service providers to start new Russian language channels in Estonia. But I think we need to bear in mind that banning something is never solely a good solution in a long-term view. There are hundreds of TV channels and thousands of websites. We will never be able to effectively ban them all. Thus, we need to get to the roots of the problem and work on media literacy skills. In addition, I think we need to offer alternative content to Russian speakers. In conclusion, I think it's important to understand that the same values, as I already said, democracy and freedom of expressions, are being used against us as weapons right now. And I think it's crucial for NATO and all the members of the alliance to draw appropriate conclusions from the ongoing conflict in Europe, which has shown to us the importance of information warfare. And it is important to improve our level of preparedness to respond to the challenges of the 21st century warfare. So thank you.
Thank you, Helen. So the establishment of ETV2 strikes me as one of those proactive kind of measures that of the kind, a very different kind of proactive measure than the ones Matt was discussing, but it's that kind of new thinking, trying to go beyond the legal restrictions that exist. Now, hearing your comments, I am reminded of this intrinsic but perhaps not insurmountable tension that exists between the necessity to curtail certain forms of speech and the imperative to protect it. Right? It's a tension that spares autocracies, but that is inherent in a democratic society like Estonia. And just synthesizing one thing that Andrea was saying earlier, because you, Andrea, you were discussing the cooperation voluntarily of the private sector. Mm. This tension, of course, comes to the fore when the private sector is not so willing to cooperate, and we know from experience that can happen. I mean, I'm thinking of the 2015 contention between Apple and the FBI.
Yes.
That was not a free speech issue, but it related to privacy and the decryption of a personal device of a terrorist, right? So I'm wondering if, mindful of that larger tension, I'm wondering if you could say something about how to manage it in situations where, for example, the large multinational social media companies might not be so cooperative in curtailing activities within their forums.
Yeah, thank you for a great question. I think it's definitely a problem how to restrict freedom of expressions, but also to respect it. And regarding big social media platforms, at least with what we can see in this Ukraine crisis, is that Google, for example, has been very cooperative with us. But in a long-term view, I think that we have legal challenges in front of us. In the European Union level, we are talking about some new legal acts that might help with us, but I think that what we can see right now is that the social media platforms are also thinking about this problem, and they are very cooperative with the governments. And I think it's just a question of time where we can find a solution, but it will take time, and we're prepared to work on that.
Well, we researchers will be watching you very closely. So by my clock, we started 2 minutes late, so I'm going to take the liberty as moderator to take us over by 2 minutes, which gives us 4 minutes for questions.
My name's Dhruv, UK private sector cyber security technology provider. My question is for the Assistant Attorney General. In the 2 examples you had where the emails were compromised and so on, what took it over the line for your office from considering these just as an acceptable level of espionage?
Yes. The 2 examples I gave, the 2 examples I gave where we took proactive measures, Hafnium and Cyclops Blink were the 2 that I highlighted. So look, I mean, in both of those cases, there was potential for significant disruption to a wide range of private sector actors. The extent of with the Hafnium, which was Chinese intelligence actors, Cyclops Blink, which was Russian military intelligence. These were not what we would consider to be traditional espionage. These were, they had the potential to be disruptive to a wide swath of our private sector, including critical infrastructure within the United States. So I don't think there was a difficult question about whether or not there was something to be tolerated here. And even in the context of what some might consider to be traditional espionage, when we're talking about cyber attacks that put at risk critical infrastructure or involve large amounts of personal data of US citizens from our perspective, we're going to be aggressive in investigating and prosecuting, as well as taking proactive measures where those are available.
So we have time for one more question, so long as the questioner cooperates. Yeah, over here.
Thank you, Piret Pernik, CCD, COE, and my questions actually follow on for the previous one, and I was wondering that my understanding is that in both of these takedowns that actually FBI accessed infrastructure located on the US soil. But for example, if it's Joint Task Force Ares operation against ISIL, it was on the German soil, as well as the previous operation, or actually not previous, but later operation against Internet Research Agency in Russian soil. So in this case, you wouldn't need a court order, you would have other legislation that authorizes those actions. But how do you actually convey this to the global audience that US follows the responsible state action, and this is a different case if you interfere with infrastructure. Do you understand what I mean?
I think so. I mean, this is was a really important part of with the recent measures that we took with regard to the Cyclops Blink malware, because that was, like all of these cyber attacks are not going to be limited to one country just by their nature, and when we're talking about nation states. And so with respect to the Russian intelligence botnet, when we took out the command and control layer, that was done in close partnership with other countries that were facing, where we were able to identify command and control servers in other countries. The FBI, with its partners in Europe and other places, reached out and had conversations, as well as at intelligence agencies, to alert those countries so that they could take action under their laws as necessary. But there was close cooperation on a multilateral basis to ensure that this was effective, because without that level of multilateral cooperation, of course, it would be much less effective. So it's a really important question.
And maybe we can have just a brief comment from Andrea and Helen regarding the international dimensions of your efforts.
It's pivotal. I mean, it is quite obvious that this type of crimes don't have borders, don't respect borders. So it's essentially, I think at European level we have developed very legal tools. For example, the Joint Investigative Team, because obviously using MLAT is a very slow process. Right. I mean, so multilateral cooperation is essential. We develop a fantastic cooperation with the FBI, which is essential for us. For example, quite lately we managed an operation, international level, also in Italy, on the use of the dark web to spread terrorist propaganda. And for example, in order to overcome the obstacles to cooperation with MLAT, by MLAT, with the FBI, for example, we conduct parallel investigations, yes, and we exchange information at the police level, and then at the end of the operation, we can formally ask the use of this evidence in the respective police. So, I mean, I think this is a field in which really a lot of improvements in late years have been done. I mean, at the international level, the cooperation. Obviously, more must be also done.
And Helen?
Yeah, from our side, I think talking about the websites, what we did was to restrict access from Estonia to those websites. Mm-hmm. That can be done, but regarding the cooperation between states, I think in an EU level at least, we have a great example of giving sanctions against those media outlets coming from Russia. Therefore, I think the sanctions is one way, but we need to find some kind of a good solution how to actually restrict access to the source. And if it's from another state, for example, in this case from Russia, how can we do this from the EU or from US side? Yeah.
So ladies and gentlemen, usually at a conference like this, given the enormous challenges of addressing foreign cyber threats, I usually try to stem any soaring optimism that might arise, but I think that in the last hour we've been given some basis for it, discussions about and illustrations of how government institutions can indeed adapt themselves and mobilize the legal arsenal to this end. So please join me in thanking our three speakers, Matt, Andrea, and Helen, and also Davide Giovanelli and Tatana Yancharkova for their indispensable support.